Good morning, everyone, and welcome to today's webinar on settlement agreements. I'm David Clay. I'm a legal director in the employment team at Field Seymour Parks, and I'm going to be talking through when, why, and how to use settlement agreements with your employees. Apologies for starting a few minutes late this morning. We're using a new platform to deliver our webinars, and as always happens, you just run into a few technical gremlins behind the scenes. But hopefully, you can hear and see me fine now, and see the slides as well. So just before I get going, just a few housekeeping points to run through. So obviously, this is a remote webinar. If we have any further technical problems, then please bear with us and we'll try to resolve those as soon as we can. You can just hopefully pop a comment in the chat box at the bottom of the window if there's any technical issues that you experience. It's going to be 45 minutes long, so try and keep to that and finish by 10:45. All attendees are on mute, but if you've got any questions as I'm going through the talk, then feel free to pop them in the Q&A box. So the chat box for any technical issues, the Q&A box for any questions to me, and I'll endeavour to pick them up at the end. If I run out of time, then I'll come back to you on email later on. There will be a couple of polls during the webinar, so please do get involved with those. The webinar is being recorded as well, so if you have to pop off for any reason, you can always revisit the parts that you missed later on when you get the recording. And there will also be a survey at the end, which I think will pop up when we close the window. So be very grateful if you could fill that out and provide any comments and suggestions for future topics. Okay, so if we move on to the next slide, what I'm going to cover today. So in a moment, appreciate there might be a bit of a range of experience of people on the call, so I'll just do a quick introduction to settlement agreements for those who are perhaps a bit less familiar. I'll then talk about when to consider settlement. So I've split that up into sort of more proactive versus reactive scenarios, why settlement might make sense. So the sort of factors for you to take into account when you're considering whether or not settlement might be a good option in a particular scenario. And then the sort of the how section of the talk is split into two. So firstly, off the record discussions. What do I mean by off the record? We'll go into that in a little bit more detail, how off the record is off the record in reality. So we'll talk through that and how to conduct those discussions. And then I'll finish off towards the end of the talk running through some key drafting points. So obviously the financial points that you want to cover, and also some important non-financial elements to apply your mind to as well. And yeah, hopefully if we got time at the end, then I'll answer a few questions. So do put those in the Q&A box as we're going through. Okay, so I think next slide is the first poll. So fingers crossed the tech will work on this, and you'll see this poll box on your screen. So really just for my own interest and a little bit to help me tailor the talk as well. Which of the following options would best describe your experience in handling settlement arrangements? So you feel comfortable issuing draft agreements and also holding off the record conversations. You've worked on numerous agreements and understand the key concepts. Maybe worked on a few agreements, but don't feel particularly confident, or you've got really no experience at all, but keen to learn a bit more. So just give you a couple more moments to key in your response to that, and then let's bring up the results. So okay, so we've got 11% for both the first two options. So relatively small proportion of people on the call have got a lot of experience with settlement agreements. The majority have only worked on a few agreements perhaps, or don't really have any experience at all. So That's great. Hopefully, you'll find this talk informative, and you'll go away knowing a bit more than you do at the moment. So, on to the next slide then. Introduction then to settlement agreements. So, what am I talking about here? What is a settlement agreement? Well, essentially, it's a legally binding waiver of the contractual and statutory claims which an employee may have, which arise out of their employment or its termination. So that's it in a nutshell. It's a waiver of contractual and statutory claims. Now, the statutory claim waiver is really the key when it comes to settlement agreements because it's comparatively easy. And well, maybe easy is the wrong word, but it's easier and there's less formality involved when you are just looking at settling contractual claims. When it comes to statutory claims, the waiver of those types of claims is a lot more heavily regulated, and that can only be validly done through a settlement agreement or through a COT3 agreement, which I'll come to in a moment on this slide. When you're securing a waiver of claims, typically that will be against the company the employer that employs the employee, but also against the wider corporate group that the company is a part of, as well as any directors and employees of the company as well. So it's a very broad, comprehensive waiver of the employee's claims. Now, what's the quid pro quo for this waiver of claims? Well, of course, you need some consideration for that, and money of some form of financial payment is the key bargaining chip that you have to persuade employees to enter into these agreements and waive their legal rights to pursue claims against you in a court or employment tribunal. Now, settlement agreements aren't just about the financial terms. There are other important non-financial elements to consider as well. But in a nutshell, that's what we're looking at. We're looking at the waiver of contractual and statutory claims that an employee might otherwise be able to pursue against you in a court or tribunal. And in exchange for that, you're giving them some form of consideration, which is typically a cash payment. Other points to be aware of with settlement agreements, they've got to be in writing. So you may feel that's self-explanatory, but you can't verbally waive statutory employment claims. So it's got to be recorded in writing in a document. Independent legal advice is a key one. A lot of employees will not always appreciate that they can't just take an agreement away, sign it themselves, and give it back to you. It won't be legally binding and enforceable unless they've gone away to take independent legal advice on the terms of the agreement, which 99 times out of 100 will be going away and speaking to a solicitor to run them through the terms. There are some other categories of people that can advise on agreements, but most of the time it will be an independent solicitor. Just the final point on that slide then, settlement agreement versus COT3 agreement. So you may or may not have heard of COT3 agreements. They are effectively a shorter form of settlement agreement. So you don't get as much of the detail that you would include in the standard long form settlement agreement, but there are as I say, typically a shorter form document that can be used to agree a settlement. Importantly, that can only be used where there has been negotiation through an ACAS conciliator who has then helped the parties to achieve a settlement of their claims. So COT3 agreement only available through ACAS. Some of the advantages of using a COT3 are that as distinct from the settlement agreement where there must be independent legal advice, with a COT3 agreement, you don't actually have to take independent legal advice as an employee. The employee may choose to do so anyway, but it's not a statutory requirement in the same way that it is for a settlement agreement. So that's one advantage of the COT3. Another advantage is that certain employment claims can only be waived using a COT3 agreement. So an example would be claims related to failure to properly inform and consult with an employee in connection with a TUPE transfer scenario. So that would be where you've got the sale of a business or a service provision change following an outsourcing or retendering, for example. And there are a few other examples, but the COT3 agreement has value in that it can be used to settle some types of legal claims that will not be effectively waived if you try to achieve that via the standard settlement agreement. Okay, so let's move on to the next slide. Um, when to consider settlement. And as I say, I've divvied these up into sort of proactive and reactive scenarios. Now, this is by no means an exhaustive list of all of the different types of situations in which you might want to consider settling, but these are some of the most common. So to start off with, where you've got issues with poor performance, I think this is really one of the most time-intensive HR processes that you can go through. There's a lot to do when you're implementing a performance improvement process. You've got to draw up the PIP documentation, think about smart targets that you're going to implement, so specific, measurable, attainable, realistic, time-based. Often you'll need to provide extra support to that employee to help them meet whatever targets you've set. There'll be additional HR and management time to attend meetings and monitor whether performance is improving to the required level. And often it can be quite an emotive process for the employee as well, because they're essentially being told, well, you're not really up to scratch in your role and you need to improve. So performance process is often pretty difficult, and therefore settlement can be an attractive alternative to going through all of that. Redundancy. So while not generally as lengthy a process or as time consuming as performance, nonetheless, there's quite a bit of thought and admin to go through to effect a fair redundancy dismissal. You've got to think about pooling, you've got to think about scoring, what objective selection criteria are you going to use. Again, it can be a little bit emotive because let's say you've got 3 people doing a particular role, you decide you only need 2. The person who's provisionally selected as being at risk may not agree with your assessment of their abilities, their skills, etc., relative to their colleagues. Those conversations can be quite difficult. They might challenge the process that you've gone through. So again, settlement can be a helpful alternative. Also, if you are considering maybe voluntary redundancies before getting into the detail of a full redundancy process, then you may decide that you're going to offer people the opportunity to apply for redundancy on enhanced terms. And if you're doing that, then the recommendation would be that you use a settlement agreement to record those terms and ensure that you're not just paying over the odds for somebody to leave, only for them to still have the ability to bring claims against you. Restructuring, often quite closely linked with redundancy, but with restructures, you sometimes have a question as to whether there is actually a redundancy scenario and whether that technical definition of redundancy has been met. So sometimes you might be creating a couple of new roles within the business and shifting work about from one person to another, but there isn't really a reduction in the amount of work that needs to be done or the number of people that you need to do that work. And employees can sometimes find it tricky to sort of appreciate the legitimacy behind that type of process, and it can be challenged a little bit more. So with those types of situations, again, settlement can help to give you a sort of smoother path to exit somebody. I've put disability-related absence as the next one, but really any kind of long-term sickness absence. It can be worth thinking about whether settlement is a good alternative. The classic first step when you've got somebody off sick for an extended period of time would be to try and seek some independent medical evidence. So typically GP report or occupational health report. But as some of you may have experience with, those reports are not always the most helpful. They can sometimes be drafted in quite vague, high-level terms. And obviously, when you've got somebody off on long-term sick, you've got that question of whether they might have a disability for the purposes of the Equality Act. If they do, you've got questions about how far you can go with making reasonable adjustments. If you get things wrong, there can be claims for failure to make reasonable adjustments, for disability-related discrimination, and those awards are uncapped. So your exposure financially can be pretty significant. So again, settlement worth giving some thought to in those circumstances. And then the final point on the slide, senior exits. So I think unless you've got a very clear incidents of, let's say gross misconduct dismissal for somebody in a very senior role, running any other type of formal process for the most senior people in your business, so CEOs, MDs, board directors, etc., the decision makers and people responsible for the company strategy, can just be very difficult in practice to actually implement. It's often extremely disruptive. There's sort of a loss of leadership and direction while those processes are being progressed. And therefore, a lot of the time when you're dealing with the most senior people in an organization, it just makes more commercial sense to agree settlement terms with them. You've got issues as well, often around statutory directorships, shareholdings in the business, often for these senior people. So yeah, senior exits we commonly see resolved through a settlement agreement rather than through a formal process that you might apply to other people working within the business. Okay, so let's move on to the reactive scenarios. So sometimes employee may come to you with a proposal to settle. It's not always going to be born out of some negative experience. Maybe sometimes people want to move on. They want to move to a different area. They perhaps don't want to work out their notice periods. Maybe that suits you as well. And you can have perhaps relatively amicable discussion, but you just want to use a settlement agreement to dot the I's and cross the T's, make sure there's no loose ends, and deal with it in that way. However, obviously, that's probably in the minority when it comes to employees coming to you asking for settlements. A lot of the time, that's going to be in the context of having submitted a grievance. Then they're not happy. Grievances obviously take a lot of time and effort to review and investigate. You've got to pull in a number of people who've been named in the grievance to get their version of events. So you're in a scenario where there's probably strained relationships within the business that might be affecting your business objectives or the harmony of the wider team. Perhaps other people are unhappy and they're thinking about leaving. So with grievances, certainly worth thinking about settlements as an alternative to going through what can be quite a labour-intensive process. And then the final point on this slide, obviously tribunal litigation. So tribunal claims are often settled on a purely commercial basis because of the time and costs involved in defending them. There's general litigation risk to consider with tribunal claims, even if you think the claim lacks merit. Employment judges are not infallible. Sometimes they can prefer the claimant as a witness over the company's witnesses. And I think one important thing to remember with tribunal claims is you sometimes get this sort of scatterboard approach for employees. They'll chuck a load of mud at you and hope something sticks, bringing you know, big range of claims, but they only have to win once with their claims for that to open the door to financial remedies. So even where you think you're in quite a strong position with litigation, you've always got that risk that your witnesses might say something unhelpful when they're being cross-examined, that the judge may just prefer the claimant's evidence to yours, etc. And so, yeah, litigation is probably the most common scenario where you're reactively considering settlement. Okay, so I think our next slide is the second poll. So let's get that up on screen. Hopefully, there we go. I think that should be visible now. And just been talking about tribunal litigation, so I thought I'd ask, according to ACAS figures, what percentage of employment tribunal claims do you think are withdrawn or settled before we get to the final hearing? So four options for you there. Is it 20%, 40%, 60%, or 80%? This is ACAS figures I found from last year, so it should be pretty up to date. Let's see what you think. Results coming up. So yeah, nobody's gone for 20%. It's probably leading you away from that answer with my previous comments. The ACAS figures are that 80% of claims issued in the tribunal are either withdrawn or settled before the final hearing. I don't have the exact figures on what percentage are withdrawn versus what percentage are settled. I think it's about 30% withdrawn, 50% settled, something like that. But anyway, you can see that a significant proportion of tribunal claims never get to the final hearing, and a lot of those are because there's been a settlement deal reached in the meantime. So certainly, certainly just underscores that it's worth giving some thought to settlement whenever you get a tribune claim in. Okay, let's move on to the next slide then. So why settlement might make sense. And I probably touched on some of these points already, but essentially what you want to do is conduct a little bit of a cost benefit analysis in each scenario. So obviously on one hand, you've got the direct costs of funding a settlement agreement through the payment that you're going to make to the employee under the terms of this agreement. But that's got to be offset against other factors that would apply if you don't settle. So I've got a few of those listed here. Time is one of the main ones. So, HR time, management time, leadership, colleagues that need to be spoken to, people potentially having to act as witnesses in the tribunal proceedings in due course. So it's quite a big drain on a number of people throughout the business in defending these claims, or working through a formal process, as the case may be. That in itself is obviously pretty disruptive in terms of both the loss of time, but also in terms of a divergence of focus away from things that you might want people to be more focused on. It can interrupt people's ability to drive things forward in their day job, so to speak, or maybe it stops you from starting work on a new project because everybody's having to deal with this formal process. Emotional toll is certainly important to take into account. Can be pretty stressful if you're having to deal with litigation or formal processes. The employee can be pretty emotional or angry towards certain people in the business. So that certainly needs some thought as to whether, if you don't settle, you're prepared to go through the emotional stress that's going to come with dealing with the formal process. Costs, of course, you have direct costs if you're instructing lawyers or HR consultants to assist you with any process as an alternative to settlement. And then you also have sort of the indirect costs, which are perhaps a bit harder to measure, of people having to spend their time running formal processes as opposed to um, spending their energy doing something more productive. Liability, so as I mentioned on the previous slide, there's always a risk that that you may ultimately come out on the wrong side of any litigation that is pursued. And reputationally as well, hearings in the tribunal final hearings are held in public. The tribunal publishes records of its judgments, the decisions that it's reached. So all of these, all of these sort of negative factors uh, are important to consider in the round when you're thinking, well, what is in the best long-term interests of the business here? Yes, there's going to be an upfront cost to settlement, but is it worth it to avoid the time, the disruption, the emotional toll, the cost, the risk of liability, the reputational damage? A couple of points at the end of this slide. Uh, fully understand that some claims are very much lacking in merit, and there's an enthusiasm often at the start of a claim, in particular, if we're just focusing on responses to legal claims, about fighting points of principle with employees, which is understandable and admirable. Uh, but again, there's a price to doing that, and how much you're prepared to give up, so to speak, in order to stand behind that principle. What we often find is there's a lot of enthusiasm and people feeling they're in the right and they're going to defend claims and defend their position at the outset of a matter, but then as it rumbles on, as the impact of that starts to be felt throughout the business, often enthusiasm wanes with time when it comes to fighting people on points of principle, and pragmatism can win out. But of course, if you always settle at any time there's a formal process or a difficult scenario or someone's alleged some wrongdoing, then is that sending out the wrong message to your workforce, and also potentially costing you more than it needs to at times. But I think there is a bit of a risk that if you get a reputation as an employer for just settling, then you can encourage people to come forward and just have a go to see if they can extract some money out of you in circumstances where actually they don't really have any that don't have a leg to stand on, so to speak. So important to consider all of this in the round. In reality, I think it needs to be a balanced approach, that you review it on a case by case basis rather than just having a fixed strategy that we're going to settle everything because it's too much hassle, or we're not going to settle everything because we don't we don't want to encourage people to try it on with us. I think that it's important to have a bit of flexibility and consider it on a case by case basis. Okay, so next slide. Let's say you've decided you want to try and settle. You'll need to have an off the record discussion. So what does that actually mean? Well, technically, we're either talking about without prejudice discussion or a pre-termination negotiation. So what's the difference? Well, without prejudice conversations only apply where you've got an existing dispute. So that's where litigation is already in progress, or it can be reasonably contemplated that there are going to be legal proceedings. And you're having conversations and discussions which are part of a genuine attempt to settle claims. In contrast, pre-termination negotiations, so sometimes known as protected conversations under the Employment Rights Act, so they apply, well, this was developed kind of as a response to the limitations of the without prejudice rule. So, as I say, without prejudice rule is limited to where there's existing disputes, but there's often a bit of a grey area as to whether there is a dispute or not, unless you've got proceedings that have been actually issued. So this concept of pre-termination negotiations was developed to enable employers, in theory, to have more open conversations with their employees about agreeing exit terms. Um, However, yeah, in reality, the extent of that protection is somewhat limited. Those conversations can't be referred to in ordinary unfair dismissal claims, but they are disclosable in respect of many other claims, including discrimination claims. So, whether you're having a discussion under without prejudice rule or as a pre-termination negotiation, it's important to conduct these discussions really, almost as if you're going to end up with having those discussions disclosed anyway. Um, on the basis that you want to be confident that you're not saying anything which might reflect badly on you in the event that it was brought to the attention of the tribunal in due course. And indeed, there are exceptions to these rules. So without prejudice, if there's been unambiguous impropriety or pre-termination negotiations, if there's been some sort of improper conduct, so you're trying to apply too much pressure or you're threatening somebody that they're going to be dismissed unless they agree to your settlement offer, then these protections won't apply anyway, and the content of the discussions will be disclosable. But that's what we're looking at with off the record conversation. So it's without prejudice, so it's a pre-termination negotiation. So on to the next slide. So that's what it means. What do you actually want to say then in practice? How should you go about arranging these meetings, and what should it cover? Well, there's no need to give notice of the meetings. You don't have to provide sort of 3 working days notice or anything like that. Equally, there's no right to be accompanied at an off the record / without prejudice / protected conversation. The ACAS Code of Practice on settlement agreements recommends being accompanied as good practice, but I think in reality, very few employers do that, and don't think it would be particularly helpful in the context of a confidential discussion about an employee's own employment and potential exit terms. But I wouldn't be misleading in terms of setting up those meetings. So you just want to, if you are inviting somebody to a discussion, you can just describe it as a catch up or a discussion. You don't want to be setting it up as something that it's not. At the outset of the meeting, you're going to want to set the scene. So summarize the situation that has brought you here. Explain the formal process that you would otherwise need to follow to address the issue. So whether it's performance, conduct, sickness, absence, etc. And then you can say, that we would have to go down this formal process. We're committed to doing that and following a fair process. However, I'd like to discuss an alternative way or an alternative approach to that if you're open to having an off the record / without prejudice / protected conversation discussion with me. And then you can go on to explain what you mean by off the record, which is essentially that it's a confidential conversation which couldn't be referred to in certain legal proceedings. Now, if the employee doesn't want to proceed, you can just bring that discussion to a close there and then and say, okay, no problem. We'll be in touch about next steps on the formal process side of things. But if they are willing to go ahead, then you can summarize the key terms, provide a draft agreement, and set time frame for response. ACAS suggests giving somebody 10 calendar days, but you can ask for at least an indication in principle of whether someone's interested in an agreement more quickly than that. As to whether you provide them with a full copy of the draft agreement straight away, there's no sort of right or wrong. Sometimes people are wary of doing that because they think it can look a little bit presumptuous, and you've also got the costs incurred of doing that. But on the other hand, it does show that you're serious about the offer, and you've I think it can help as well sometimes that employees then have something formal to take away and go and seek independent advice on. So the next slide on actually drafting up the agreement, what are the key financial terms that you need to cover off? Well, the obvious one is the settlement sum. Um, Now, in most cases, as you may or may not know, you can make a payment of up to £30,000 tax-free as compensation for loss of employment. And then any sum beyond that would attract deductions for income tax and employers' national insurance contributions, but not employees' national insurance contributions. So in most cases, there'll be a settlement sum. Common question is, well, how much? How much do we have to pay to settle and draw a line under this issue? And of course, the answer is, well, it very much depends on the circumstances. But as very sort of rough ballpark figures, if you've got somebody coming to you with a credible case of discriminatory treatment based on a protected characteristic like age, sex, race, etc., you're probably looking at a fairly substantial sum to get them to waive their claims, because if they succeeded in the tribunal, then the awards are uncapped. So, maybe 6 months plus of money you'd be looking at there. Performance process could easily take a few months to go through. So you're perhaps looking at something in the region of 3 months to reflect the time it would have taken to go through the performance process anyway. Redundancy, not such a long-winded process, maybe a month or so as a carrot to incentivize somebody to enter into a settlement agreement as opposed to going through the process. And then, if you think you're in a really strong position, somebody's committed what looks to be gross misconduct, then you may be paying, very little, just a nominal sum to them. So it's always going to depend on the circumstances, but just to give you maybe a bit of an idea of what figures to be thinking about. In addition to settlement, you've then got you other payments that you'd be obliged to pay out on termination. So notice pay, any accrued but untaken holiday pay, pension and benefits would typically cease on termination. But if the pylon, the payment in lieu of notice clause in the employee's contract is not limited to basic salary only, then you may have to calculate that with reference to the pension and benefits they would have received had they worked out their notice. Bonus and commission if there's a contractual entitlement or you've decided to make a discretionary payment anyway. Shares and share options, often for more senior people within the business, whether they're categorized as a good leaver or a bad leaver, can make a difference to the treatment of shares on exit. Share options that are unvested will typically lapse on termination. And then legal fee contribution. So it's not a legal requirement to contribute to an employee's fees, but it's very much common practice. Starting point probably about 500 plus VAT for basic advice on an agreement, or 750 plus VAT if there's a reaffirmation element, which I will come on to in a sec. So the next slide, other key terms, waiver of claims. So you need to identify some specific claims that are being waived within the agreement, as well as the general broader wording that seeks to capture all types of claims that might be waived. It's important to identify some specific claims that are being waived in the agreement. Are you going to want this employee to work out their notice, or are you going to place them on garden leave? You may not want them in the business, so garden leave might be attractive. Return of property and confidential information, standard clauses to be included in an agreement. Sometimes you might allow somebody to keep a phone or a laptop, but otherwise you're generally going to want all property, so keys, badges, equipment, confidential information, hard and soft copy docs to be returned on the date of the agreement or shortly afterwards. Post-termination restrictions are something to consider. So it's quite common to maybe to waive a couple of restrictions as part of the settlement agreement. So if somebody's got a non-compete restriction in their contract, you might agree to waive that or reduce its duration. If you're introducing new restrictions because somebody doesn't have them in their existing contract, or they were entered into a long time ago, or they were poorly drafted, you should think about assigning specific monetary consideration to those new restrictions. Otherwise, that can impact on the tax-free status of the settlement sum. And then a few final points here. So direct resignations, if there's a statutory director, then You may need a director resignation letter as a schedule. You might want them to give ongoing assistance in connection with any legal proceedings or internal investigations. References are typically standard form these days, just confirm job titles and dates of employment. And for some employees, you may want to make an announcement either internally or externally to staff, or in some cases to the financial markets if it's a particular senior person who's leaving. And then the final point, reaffirmation, where there's a gap between the date the agreement is signed and the termination date, then I would advise that you require the waiver of claims to be reaffirmed on or shortly after the termination date. And that's typically achieved by having a schedule to the main agreement, which requires the employee to sign that additional waiver in due course. Okay, so that brings me to the end of the talk. So kind of run out of time for questions. I'll just have a quick look and see if there are any in the Q&A box. I've got one here from well, let's have a look. So does the Employment Rights Act have any impact on settlement agreements? Are there going to be any changes of the Employment Rights Act that have an effect on how settlement agreements are entered into? There are going to be a couple of changes in terms of the use of non-disclosure type clauses in settlement agreements. It's already a little bit tricky to do that because you have carve-outs for whistleblowing and protected disclosures, but the Employment Rights Act is going to introduce some more limitations on these gagging type clauses, which might otherwise seek to prevent people talking about harassment or discriminatory treatment. We don't have as yet a timescale for the implementation of those changes, but that's something that's going to change. And then the other thing with the Employment Rights Act, while not directly relevant to settlement agreements, is this removal of the cap for unfair dismissal awards. So particularly when you're looking at senior individuals, at the moment, the value of any unfair dismissal claims is capped at the maximum of a year's salary or 118k, and it's an amount that changes each year. If you've got people earning over that, then that acts as a little bit of a brake on the value of an unfair dismissal claim. But with the removal of the cap, the potential value of some of these claims for senior employees could start to get very high. And so while it doesn't kind of affect how you draft a settlement agreement or the clauses that you can include within it, it does mean that the advantages of settling those types of claims may be higher, because otherwise you're potentially exposed to very substantial awards if they succeed. I've got a couple of other questions, but I'm just conscious of time, so I will come back to those on email later. And for now, I'll wrap up this talk. So thank you very much for attending. I hope you've found it useful, and enjoy the rest of your day.